My first question is going to be to all of you. I'll start with Mr. Barron, then we'll work down the table there. In all of your testimony, you've highlighted a number of challenges that we have with both presidential and federal management records. I want to try to bring this down to what you think is the most important challenges, each of you, of the number of things that you've said. If you were going to give me one or two most important, Mr. Barron, what would that be?
Well, I think record keeping is all about accountability. The American people deserve to know what their government is up to. And the way to do that in 2022 is to update the law to take into account there are so many new technologies that are out there, both ones that are the government is struggling to deal with in terms of like ephemeral communications, but also there are technologies that could help the government in meeting its challenges. And so we want to talk about that in terms of managing access records, including with artificial intelligence and machine learning.
Right. Ms. Wiseman?
I think the lack of an effective and robust enforcement scheme in both statutes is a problem. I mean, I've outlined in my written testimony how we can beef up the enforcement system in the FRA, which I think is really called for because the enforcement scheme as it currently exists really is responding to operating in a paper world, and we don't anymore. And with the PRA, I agree with Professor Turley that there are potential constitutional problems, but I don't think we have to go that far, and that's why I place the emphasis and think it needs to be placed on building in certain guardrails, whether it's, annual or quarterly reporting requirements, making sure that Congress and the archivists are up to date about what is going on in the White House, so we don't have a situation that after a president leaves office, we find that, in fact, there were systemic violations and records may have been lost.
Thank you, Ms. Wiseman. Mr. Turley.
Thank you, Mr. Chairman. I guess I would rank them as, first and foremost, dealing with ephemeral messaging systems. It seems to me that that has to be a priority. It should be barred. Absent a modified system that allows the recording of those messaging. The simple approach is that the use of those types of apps should be viewed as a destruction decision, a disposal decision in contravention of the federal law. Second, I would like to see the capstone system codified. I don't see why it's not. I really have, one of those things where I looked at it to see I must be missing something. But NARA has pushed for many years for capstone to be adopted by agencies. And then finally, I do think that this committee should consider the recent controversy with the override of President Trump's privilege assertions, not because that was the wrong decision. But I am a little worried about overrides in the future from President Biden on. Politics has become incredibly bitter and divided today. It seems to me that there could be an accommodation by Congress to make sure that we have a bicameral approach or to have a more detailed standard that pushes committees to find material by other sources before they take this critical step.
Well, thank you. I'm going to ask all of you again, and this time I'll start with Professor Turley and work the other way in fairness. I think all of you have seen draft language of legislation that I'm working on to deal with this situation, and Professor Turley, I think you referenced it in your testimony as well. So I'd just like to go down the panel. What are your thoughts on that legislation? Does it address some of these key issues? Just generally, what do you think about the draft as you've seen it so far? Professor Turley.
I think it's an excellent platform to address many of the issues that we've been talking about. The one area that I, quite frankly, am a little bit concerned with is the citizen lawsuit provisions, the private cause of action. I am a huge advocate of what are called private attorneys general provisions. It's just that I'm a little bit uncertain as to the standard and how that would be used. As you know, researchers and historians have sued in the past and successfully have brought actions. So I like the idea of empowering that further. It's just that we have to be a little bit careful with the Nixon case as to how far that would go without triggering a separation of powers fight and the other constitutional concerns.
The other aspect, the other parts of the legislation you support?
Well, I really like the certification requirements, particularly in some ways because it reminds officials not to use these unofficial platforms and devices. I think there are two groups of officials we're dealing with, the sort of clueless and the conspiratorial, right? A lot of people are just clueless. They move so casually between devices, you can forget. And certification sort of is a shot across the bow to saying, this is not allowed. It also is a formal federal statement that could be used against you if you say something false.
Great, thank you. Ms. Wiseman, your thoughts?
I think it is an excellent start, and actually more than a start. I really applaud how comprehensive it is. I think that it is really dealing with the major issues that we have seen and we've commented on. So I support it wholeheartedly.
Great, thank you. Mr. Barron?
I support the provisions that I've seen. In particular, though, I think the bill addresses the fact that ephemeral messaging apps should be prohibited except when they are captured or archived in what I would hope to be in the same place that the Capstone email repositories are. So I like that a lot. I like the codification of Capstone being statutory and mandatory instead of voluntary. And from my written testimony, you know that I am a big advocate of new ways of dealing with search and with providing access to the American people. And the only way to do that is what the bill suggests, is that have experts talk to the government. The government can learn from academia and industry about artificial intelligence, machine learning, and other analytics. So I'm a big proponent of that for the government.
Mr. Barron, as you mentioned in your testimony, after 2022, NARA's going to no longer accept executive branch records in paper form. Could you explain to this committee the magnitude of this policy change and the challenges it's going to pose to NARA and, quite frankly, the rest of the executive branch?
Senator, it's transformative. The fact that NARA will no longer take paper, but only digital or electronic records, means that over the course of this decade and beyond, there will be tremendous amounts of records, I've said billions, that are coming. And I'm afraid that because of personal information in those records, it's going to be very difficult to use current processes for the American people to get access to them. And so that's a very, very big challenge. But the 2022 mandate from the archivist and OMB also means that after this year, every executive branch agency is also going electronic. They're transitioning so that all of their records are being managed electronically, and that means that they need to categorize them in a certain way, and they need to dispose of them, and they need to search them for FOIA purposes. And all of that is very difficult if you have tremendous amounts of electronic records that are there. We already see that in Capstone repositories, which I support wholeheartedly because it's an archive of emails that otherwise would never have been printed out and saved in government files. But so we have to orient ourselves, we have to reimagine federal record keeping to deal with these volumes that are coming.
Well, and you talked about in some of your previous testimony about technological advancements and resources. Could you tell us more exactly what we're going to need to do and what sort of resources may be necessary to be able to get a handle around these documents?
Senator, as I stated in my written testimony, I've been a lawyer involved in e-discovery, electronic discovery, for the last couple of decades. And the legal community knows what state-of-the-art machine learning can do for finding responsive documents and filtering them for privilege. And so there seems to be a gap. There's the private sector that has some experience now with really state-of-the-art artificial intelligence, and not so much in government. There are some agencies that know about these tools from a litigator's perspective, but no one in the FOIA community and no one in the records management community are using machine learning for records management purposes, or if they do, they're very small numbers throughout the government. And so we really need to have a conversation and have experts lead that conversation so that record keeping can deal with these large volumes of records. And there are ways, there are tools that know well about and lawyers know about in the community I've practiced in that can really be helpful to the government. So why not use them?
Mr. Barron, NARA has sometimes been unable to keep up with the pace necessary to digitize records in a timely way, and certainly the pandemic has exacerbated this problem. The agency has struggled to reopen research rooms all across the country and has amassed considerable backlogs of requests as a result of that. One particularly glaring example that I've noticed is the backlog of requests for veterans records from the National Personnel Records Center. My question to you, sir, is from your perspective, what is the primary reason behind these extensive backlogs and delays?
Well, I can tell you that I'm not at NARA anymore, and so I can't speak for them. But my understanding is that this is, as you say, a very big challenge, especially with veterans records, because of what NARA has done, which is to follow CDC guidelines on COVID. They've essentially not been able to get to the backlog, and that's unfortunate. I do have good news about researchers and research rooms that I heard archivist David Ferriero say just last week that NARA is essentially giving limited appointments to researchers to come in to do their research. And hopefully that will expand to both on a larger scale for research rooms to be open and for citizens to be able to use NARA. We all want that. So I hear you. I understand that it's a large problem, but I think NARA is working on it.
Ms. Wiseman, current law does not set any requirements for the transfer of presidential records to NARA at the end of the administration beyond making NARA responsible for the records at the end of the president's term. So my question for you, does this lack of requirement around the transfer of presidential records to NARA create some real problems for both preservation and access?
Absolutely, and I think recent events really highlight this. From public reporting, I can identify at least two problems that occurred at the end of the Trump presidency. First, according to public reports, because the president refused to accept the results of the election, he delayed implementing the transfer of his records to NARA. And this is not a job that can be kept to the last minute. And I think, in fact, what this committee should consider legislatively is mandating that at the beginning of an administration, the White House work with the archivist to develop an accession plan with specific timeframes and goalposts in place, and that the archivist be charged with monitoring that the White House's compliance with such a plan, and that it advise Congress when there are problems. The second very well-documented or well-reported on problem at the end of the Trump presidency was the fact that the president took with him, we now know, at least 15 boxes of presidential records, some classified at the highest levels. Now, because of the volume of presidential material that an individual president leaves behind, it's my understanding that quite commonly, a lot of presidential records remain at the White House, even though the president has left, but they're still considered to be under the legal custody and control of the archivists. I think, again, through legislation, Congress could make it clear that no record that is under the legal custody and control of the archivists can leave the White House unless it has the express approval of the archivists. So those are two problems that we've just recently experienced and two proposed fixes that I offer.
Thank you, Ms. Wiseman. Well, I'd like to thank Ranking Member Portman for holding this hearing with me here today, and I'd certainly like to thank each of our witnesses for joining us today in this important discussion and for providing your expert insights as to how we improve federal records management. The preservation of presidential and federal records is critical to preserving transparency, ensuring the federal government is working efficiently and effectively for the American people, and protecting our nation's historical record as well. I think as we heard from today's panel, the laws and the systems we count on to preserve these important documents are incredibly outdated, and Congress needs to take action not only to strengthen the records preservation process, but to also ensure that Americans get timely and appropriate access to these important resources. As I mentioned in my opening comments, I'm continuing to work on legislation that will modernize our record-keeping practices, strengthen enforcement of our records laws, and bring the law up to date with the emerging technologies that we see on the horizon. While NARA and the entire federal government have faced some serious challenges due to the lack of resources and accessibility, I certainly remain confident that we can address these challenges and increase transparency for every American. And again, thank you to our witnesses for helping us walk down that very important road to accomplish these ends. And with that, the record for this hearing will remain open for 15 days until 5 p.m. on March 30th of 2022 for the submission of statements and questions for the record. This hearing is now adjourned.